Well, listen, thank you for the opportunity to be here. We're excited to be able to present to your group. Um, I, we'll jump right in. I'm sorry for the kind of the late start here. My fault.
No, no worries, no worries. We all experience those type of things. Yeah,
No
it's
worries.
my fault. I should double check with you guys.
No worries.
No worries.
So yeah, let me just kind of briefly tell you. So this is what you see on the screen here is what we're going to be talking about today. It's Legally Mine has has been in business for a lot of years, and we've developed a kind of a rock solid strategy for protecting our clients against lawsuits, and also we specialize in asset protection, and so we'll be talking about all of these things tonight. I'll try to keep it to an hour if I can. I would ask, there's quite a few people on this call I see, so what I would ask is that you write your questions down and hold them till the end. I think that most of the time I find that the questions are answered as we kind of go through the presentation. So and then we also have Garrett, who is with Legally Mine. He's on the call with us, and at the end of this I've got to jump to another meeting, but I will let him stay on and answer questions. He's much more educated than I am at answering the questions. So I will let him handle that at the end, and he can take it from there. So let's just get started. So let me just start by kind of introducing myself. Let's see if I can do this. So my name's Jay Solberg. My wife and I have co-owned several businesses together. I've also worked in corporate America for 40 years for Fortune 500 companies and do consulting with those companies. And I can tell you that the strategies that we're talking about today are strategies that are used by very large companies, and we'll talk about that a little bit later. But they're also available to individuals who have small companies or who are even W-2 employees, and most people are not aware that these kinds of benefits are available to them in terms of how to set up a structure so that you're protected, just as a large company would be. So I'm not only going to teach you about the strategy that I use, but I'm also going to show you the solution that Legally Mine offers that will put this strategy to work for all of you, so that you can do what you're passionate about, whatever that is, right? Jasmine, are most of the people on this call, are they associated with the medical community?
Not really.
Not really?
I think some people is entrepreneurs, some people is professional. They're all in different kind of industries. Okay,
gotcha. Well, this presentation was designed specifically. I thought coming into this was going to be sort of a medical group, which we do a lot with them in terms of associations, but this works perfectly well with investment advisors, investment groups as well, and anybody that's acquiring assets or selling assets, or anybody that has their own business set up. These apply to everyone. So excuse me in advance, because some of the slides that you see here will refer to the medical industry when in fact it applies to everyone. So
understand. They get sued a lot.
Yeah. Okay. No worries. All right. So we want you to focus on what you're good at. Running your business. By investing in real estate, whatever that is. You do what's good, what you do best, and let us take care of the asset protection, lawsuit prevention. So we've been serving medical professionals and professionals in general for over 40 years. We have a rock solid strategy. We have a track record that's pretty impressive. I'm not an employee of Legally Mine, but I present for them, and I do this because I like it. I'm passionate about it. I have my own businesses. I do my own consulting work with larger companies, and I've been a client of Legally Mine for about 12 years. And so I've been here long enough. I know the kinds of things that people are facing when it comes to being exposed to lawsuits and things like that. So I'm passionate about this, and so they invited me to speak for them, which I do almost every week. So we're going to talk about how we can make it so that no lawsuits continue. I'm not talking about just having lawsuits dropped. I'm talking about, or settling. I'm not talking about that. I'm talking about having them drop before they ever get to the point where they even go to court. So, Legally Mine has this, has a a strategy also that involves tax savings, so that, you know, once you have your entity set up appropriately, there's some dramatic tax savings that comes along with that. So even for you, whether you're a W-2 employee or a 1099 contractor, or whether you own your own business, you know, we can save our clients an average of $10,000 to $12,000 a year if you're a W-2. If you own your own business, $15,000 to $20,000 a year, just in tax savings by putting the right structure together. So, so Legally Mine is the most, you know, we're the largest, most experienced asset protection company, and we've been serving, you know, business owners for over 40 years. But for the last 12 years, we've got this really unique, rock solid strategy that we've developed, which we're going to be talking about today. So why do we even need to protect ourselves? Well, you know, we drive down the road every day, and every other billboard features an attorney, right? And you see things like this. You know, Dan got us $600,000. How much can he get you? What is your case worth? So it's not surprising that Americans are litigious, but what's crazy is how bad it's really become. You know, did you know that the United States constitutes only 5% of the world's population, but represents 90% of the world's lawsuits? So it's so bad that last year alone, there were over 100 million lawsuits, just in 1 year. So, you know, so why so many lawsuits? Well, it's the attitude of many Americans today, right? The USA Today did a survey, and they asked people, what's the best way to get ahead or to get rich in America? And one of the top 3 answers was sue someone. I think the number 1 answer was inherit it, but one of the top 3 was sue somebody. So, you know, if that's the attitude of Americans, is it any wonder why we have so many lawsuits? And, you know, if we know that we have this legal problem, this litigious problem in America, you know, why don't we fix it? You know, it's our laws. They not only not fix it, but they perpetuate it, and it's only getting worse. You know, think about this. We have a nation that's literally run by attorneys. Congress makes the laws, and who are the Congress members? Well, 90% of the seated Congress members today are attorneys. So attorneys make the laws, and then you hire an attorney to fight the law in front of a judge who, oh yes, he or she is also an attorney. So they write the laws, they fight the laws, and then they judge the laws. So who on earth is that whole system built around? It's not built for you and I. It's built around attorneys, and they want, you know, it sounds crazy, but they want to be able to sue. They want people to have the ability to sue, and there's some good reasons for that. We'll talk about that, but that's why it's so bad in America. You know, it's the laws. Think about this. We're the only country in the entire world where there's no ramifications for suing someone. The laws make it possible for anyone to sue for any reason and hope to win, with no ramifications for suing and losing. And that's because who makes the laws? Well, attorneys do. And with this system in place, lawsuits continue to climb into record numbers year after year. As the suits just keep getting bigger and more frequent, you know, that's what's happening. And are your odds of winning actually getting better? They're not. Statistically speaking, in 7 out of 10 lawsuits, the court awards a settlement averaging between $3,000 and $75,000, which means that you have a 70% chance of losing if you get sued. So those aren't very good odds, right? So that's the bad news. The good news is that you can beat the odds. And I'm going to teach you four basic key strategies that come together like a beautiful puzzle, each one fitting perfectly together and acting as a protection for you to keep a lawsuit from ever happening. Not getting rid of it by settling, but getting a suit that comes your way dropped and never happening at all, like I said earlier. So that's what these 4 strategies are going to do. They're going to make sure that it never happens at all. So I'm going to show you exactly how we use uniquely structured entities with a strategy backed by the Supreme Court to provide rock solid asset protection, and how the strategy will save you an average of $10,000 to $20,000 a year on your taxes. And then I'm going to show you a solution that handles the entire thing for just 3 to 4 hours of your time. So that's what we're going to be talking about. So let's get started. So how does it work? Well, it all comes down to cause and motivation. Every lawsuit is about those two things, cause and motivation. The cause we can't control because life happens, right? But motivation we can control and we must control. So we have an office full of attorneys, and they, just like a lot of people that are in different professions, have to attend conferences occasionally for continuing education credits. And so our attorneys were at one of these events where they were there to get some education credit to keep their licenses active. And so they attended this conference. And one of the subjects that was advertised, one of the classes they could attend, the headline was how to ensure a 7-figure settlement when suing someone. So, and of course, since it's our job of protecting people from these kinds of attorneys, this was a good session for our people to attend. So the attorney teaching the course proceeded to tell them about one of his most recent cases with a woman named Carol. So Carol had been to see her doctor, and when she was leaving, the receptionist called out to her that she had forgotten to take her paperwork. And as she turned to go back inside, the heavy glass door hit her foot. It knocked her to the ground, and when she hit her head, unfortunately, she damaged a part of her brain responsible for taste and smell. So it was a really bad situation. It was unfortunate, but she sued. And so she came to this attorney. This is the one that's teaching the class now, remember? And she mentioned that she was looking for $60,000 because that should cover her medical bills. But this attorney said, hey, let's not get hasty. Our first step is to see what this business owner has, what this doctor has. And after doing some due diligence, he found an umbrella policy. So check. He found a general liability policy. Check. But what else could they get? This doctor, he might have some deeper pockets. Let's see what's on the table. So what did he find? Well, he found bank accounts. He found that this doctor owned his own home. He had investment accounts. He owned real estate. All of it was on the table. Nothing was protected. So motivated now, this attorney determined to take the case and just go for it. So then he proceeded to go through 47 different focus groups to understand, the type of jury that he would need to win the case, what his best arguments were, how to present the information in a way that would win the most empathy, from the jury. And his selected jury, oddly enough, ended up being middle-aged, overweight males. They were the most empathetic to the loss of taste and smell. And so his closing arguments went like this. He said, close your eyes, remember back to when you were 5 years old. It's a Saturday morning and you woke up to your mother making you pancakes and bacon with fresh maple syrup. Well, guess what? You'll never smell that again. You'll never taste that again. Those memories are lost forever. So guess what the outcome of that lawsuit was? The plaintiff was awarded $5.2 million. Can you imagine how frustrating that would be, if something like that happened to you in your life? You work your whole life trying to earn, earn enough that you can leave something for your posterity and make a good life for yourself, only to have all of that taken away because of a lawsuit that happened. Keep in mind that this doctor, this practice owner of this doctor's office, he didn't do anything wrong. He did nothing wrong. It wasn't his fault, but it happened. And so, we're going to come back to this. I'll tell you what the outcome of that was and how that all worked out. I'll tell you that a little bit later, but it makes me wonder what he would have paid himself to have saved himself from going through a lawsuit like that. What would he have invested to save himself from all of that? So my point is that we've got to take control. We've got to stop leaving our life to chance. And we do that by taking motivation off the table. So let's look at what motivation, you might have on the table. If someone is looking at you, what are they going to find? Well, let's start with safe assets. Safe assets are valuable things that by themselves would not cause a lawsuit, but they're named in a lawsuit, but they're not necessarily, they don't cause them. So that's why they're called safe assets. These are things like bank accounts, investment accounts, life insurance policies, retirement accounts, cryptocurrency. You see all these things here. All these are valuable things that, that would be on the table in a lawsuit. So how do you get these assets off the table? So that's strategy number one, which we're going to talk about here. But But this strategy that I'm going to tell you about takes 99% of your safe assets, it puts them in a vault, and it hands you the only key. And that's what we want to do. So welcome to strategy number one, which is the family limited partnership. And the family limited partnership acts like that vault for storing all of your valuable safe assets, and it hands you the only key. So in a family limited partnership, there's a general partner and there's limited partners. The general partner holds the key to the vault. They have 100% control of all the assets, and because of that, they take on 100% of the liability. Now, this could be you, it could be your spouse, it could be, it could be others, it could be a child. But how much ownership do we want to give the general partner if they hold all of the liability? We want to give them as little as possible, right? Which happens to be 1%. So that's the least amount possible, but it makes it so that the general partner has only 1% liability, but they still have 100% of the control. Does that make sense? Okay, so we've got 99% of your safe assets are now off limits, off the table. Now, who are the limited partners, right? Limited partners could be you, it could be a spouse, it could be children. It's completely up to you. Limited partners have no control and therefore no liability. So we're going to place 99% of your assets under this ownership with no liability. Okay. So if you're married, you might consider setting up a management company where both you and your spouse can be 50-50 partners. Some of you are probably already set up that way. That way you share equal control, but your liability is still limited to just 1%. So strategy number one is to create that FLP and place all your safe assets in it with a 1% general partner protecting 99% of your safe assets from liability. All right. So that's the first strategy. So now we've protected 99% of your safe assets. Let's look at what other assets you might have on the table. Let's look at your high risk assets. Now, these are assets that can by themselves be responsible for a lawsuit. And that's why we call them high risk. So what high risk assets do you have on the table? Well, these are things like your office or firearms or equipment, boats, RVs, outdoor vehicles and toys, home, rental properties, other property, business and, interests, equipment, land, more. There's a lot of these. How do you, if some of you have some of these assets, how do you get them off the table? Well, here's strategy number two. Using individual and unique entities like limited liability corporations or limited liability companies to protect each asset. So the key to strategy number two is that we set up individual entities for each of these assets, and we make sure that we don't have liability from one asset leaking into another. So that's the key to doing those right. So let me give you an example. What if you had 3 rental properties and you set up an LLC so that you could limit your liability? What happens if just one of the properties has a fire and the renter sues? What's available in the lawsuit? Let me just pause there and ask that question. Anybody want to take a gander at an answer?
The renter will sue you, right? Because they have 2 other assets in the LLC.
Yeah. So everything's available. All 3 of those properties would be available in that lawsuit, not just the one that caused the fire, but all 3. So, we like to call this cross-contamination of liability, and that's not what you want to do. So if we use strategy number 2 effectively, each of these assets are protected individually so that if a fire happened in one of them, all the other 2 are completely unaffected. They're not involved in the lawsuit. So that's the key to using strategy number 2, and it's these individual LLCs. So, who uses these kinds of strategies? Well, you've heard the saying that if you want to be successful, do what successful people do, right? I think we can all agree that Disney is pretty successful. They're worth over $140 billion. Talk about a target on your back. But here's what's interesting. I just took my grandsons, I have 2 of them. I took them to Disney World last year. And I went up to the gate and I bought a ticket. I didn't have to sign one thing limiting my liability. limiting their liability. I didn't have to sign anything. And so, I could be a 92-year-old man with a back condition, a bad heart. I can walk into Disney World. I can get on any ride, and I can take that ride. And if, how do they do that? Talk about liability. It's like, how do they get away with it? Well, I'll tell you how. Let's say that I'm going to give you a little example. Let's say that I'm that 92-year-old man, and I walk onto Thunder Mountain, and I'm not paying attention, and I'm on the ride, and it makes a sharp turn, and boom, I hurt my back. Okay, so big surprise, I go and I sue Disney, right? So they look it up. Okay, when did the accident happen? Okay, I see Jay there. He's getting on Thunder Mountain at 2:00. I see that he's getting on Goofy cart number 4. Let's see, who owns Goofy cart number 4? Well, Goofy cart number 4 LLC. So your suit is with Goofy cart number 4 LLC. Guys, what does Goofy cart number 4 LLC actually own? That's right. They own Goofy cart number 4. That's it. So here's a wrench, here's a screwdriver. Hey, take it. Put that thing in your backyard. We'll replace it. Does that make sense? So Walmart, the same thing. You fall down in a Walmart parking lot. You think you're going to sue and hit the jackpot until you find out that the only thing the Walmart parking lot owns is asphalt. Here's a pickaxe, here's a shovel. You take it. We'll replace it. So now think about this. If Disney and Walmart, these other companies they've hired teams of attorneys to represent themselves in using this strategy, why aren't you? Because you definitely have access to these. So guys, my point is that when there's nothing to get, when motivation is off the table, there is no lawsuit. So with strategy number 1, taking 99% of your safe assets off the table, and strategy number 2, protecting 100% of your high risk assets and removing them, you're off to a really good start. So maybe you're even feeling pretty good right now because maybe some of you have some of these protective layers in place already. But if we were that easy, we wouldn't have 100 million lawsuits being fought every year, with 70% of them ending up in you paying out, right? Remember, attorneys make the laws. Well, I'm about to show you how sneaky that whole circle of control is, and I need you to think like an attorney. If people start getting smart and protecting their assets with entities, and if you could pass a law to help you win anyway, what would that law be? Perhaps you would pass a law that goes around them or through them, right? Because these entities are so good at their job of protecting your assets, trial attorneys simply don't like them. They hate them. They hate limiting anyone's liability, so they despise limited liability companies, especially when they're used correctly. So they passed a couple of laws to get around them or through them, or to simply get rid of them. So the first law is a piercing law. It states that if a company is owned by fewer than 100 people, it is considered closely held. Judges can choose to pierce the corporate veil of closely held companies and put your assets back on the table. Well, if you have a limited liability company, is it owned by less than 100 people? My guess is that 99% of the people who are on this call have less than 100 employees. So that means that you can be pierced and your personal assets are back on the table in a lawsuit. So now when piercing wasn't working 100% of the time, they created a law, and it's since been put in place in 45 out of 50 states. So almost every state now has this. It's a corporate dissolution law, where judges can find a number of reasons to simply dissolve the LLC as if it never existed. And then boom, your personal assets, they're back on the table. How on earth do you fight this entire system? Well, there is a way, and we have it. So it's time for strategy number 3, which is the Alaskan Holding Company. So with the FLP, or Family Limited Partnership, protecting your safe assets and your LLCs protecting your other assets, we need to protect those entities from piercing and from dissolution. And we're going to do that with an Alaskan Holding Company. Now, this is not something that you can do on your own unless you're actually, you want to become an Alaskan citizen, but we can, and we do it for you, and it's powerful. And here's why. In Alaska, they have 2 laws that we leverage. The first is an anonymity clause. In Alaska, you do not have to disclose the owner of an entity. so it cannot be pierced. The second is that Alaska is one of 5 states that do not allow dissolution, so it cannot. So there are five other states that don't allow it. I'm going to tell you why we use Alaska. But so if your entities are held in an Alaskan holding company and a judge tried to pierce one of your entities to get to your personal assets, he would say, oh, this entity is owned by an Alaskan holding company. Well, who owns Alaskan holding company? Don't know. We can't tell you. It's against the law. Okay, so let's dissolve it then. Sorry, Alaska does not allow corporate dissolution. Do you see how that works? So there are 4 other states that don't allow dissolution, but they don't have the anonymity clause. Alaska has both of those. That's why we use Alaska. And then there's one other big reason that we use Alaska. Currently, over 35% of Alaska state revenue comes from outside businesses. So if they were to change their laws, what would happen? Well, it would bankrupt their state. And that's why they're not likely to change their laws. And they haven't for many, many, many years. So our attorneys keep in touch with that. And you know, if we ever needed to change the states in which we form these entities, we certainly would do that. So, okay, so with the first 3 strategies in place, we now have 99% of your safe assets protected in the FLP. We have 100% of your high risk assets protected by those individual entities, and your entities are protected by that holding company. So your assets are off the table. So what's the next move? You know, again, we have to think like attorneys. Remember, they make the laws. If they can't get to the assets directly, you know, and they can't get around them or through them by protecting, you know, what's the next move? Well, if you're an attorney and if you could pass a law to solve this problem for you, you know, what law would you pass? Well, what about a law that allows you to take control of the entity? I mean, heck, if you can't get around it, just control it, right? Well, big surprise, they passed a law that does exactly that. It's a backdoor sneak attack into your life and your business. It's called the charging order, and it was ratified in all 50 states. It's basically a law that states who has the right to take control of the money from a company and give it to somebody else. Well, if it's your company, that should only be your right. So, but they created this pro rata distribution clause to give the judge the authority to force you to pay a distribution to someone who sues you and wins. I mean, what's going on here? You know, they figured out that they couldn't get their hands on your stuff, so they created a backdoor loophole that allows the judge to sneak in the back door of your company and take control of the money. Well, this is what happened to that doctor that I told you about earlier. That doctor in the Carroll case. Remember, he lost $5.2 million in that. That was what the plaintiff was awarded. Well, the general liability insurance paid out $1 million. Then the umbrella policy paid out another $1 million, but that still left, you know, $3.2 million on the table, right? So they liquidated all of his business assets because he left them on the table, and that generated another $1.8 million, but that still left $1.4 million owing. So now what? Well, the judge did just this. He issued a charging order. He took control of the doctor's practice and the doctor's business. He put the doctor on a $45,000 a year salary and then paid every penny above that to the plaintiff until the $1.4 million had been satisfied. So think about that. What would happen to your life, your family? How long would it take you to be working to pay someone else if that happened to you? Well, more importantly, how do you keep this from happening to you? Well, when we realized what was going on, we, with this pro rata distribution clause, our attorneys said, we're going to change this clause and we're going to write a new one. We're going to rewrite it on behalf of our clients to a non-pro rata distribution or a non-pro rata clause. And that is exactly what we did, and it worked. So a non-pro rata clause says that only the general partner, which of course is you or your spouse, right, can ever order a distribution and give money from the company. So we cut the judge out completely. That means that instead of the judge having control, they have to ask the general partner to issue the distribution. Well, you are the general partner, and would you like to issue the distribution? No, heavens no. And the judge has no authority to make you. So of course the trial attorneys were not happy about this, so they fought it all the way to the Supreme Court, but the court said, you do have the right to change that clause for your clients, and they handed us a ruling giving us the right to help our clients by changing this language. Well, if you were a client of Legally Mine, would you want that clause changed in your documents, in your papers? Of course you would, and we do that. We replace that clause in every entity for our clients. Let me pause here and just tell you this. This is really important. This is what differentiates, really good asset protection attorneys that know their stuff from others, because not very many attorneys are good at this. So it's a really important part of what we do. When we take on a client at Legally Mine, we have to review all of their existing documents, and we look for those clauses that protect our client. And we have yet to find any document that has that non-pro rata language in it. And so we have to change that in every document that we receive. So that it's really important, and it creates a huge advantage for our clients. So here's what's really crazy though. So this is where it gets fun, because that non-pro rata language is a huge strategic advantage because it becomes an offensive weapon. See, if there's a lawsuit and the judge issues a $1 million settlement, who's the first person to get paid? The attorneys, right? The attorneys are going to get paid first. Yeah. And then who's the second? Who gets paid secondly? The IRS.
The IRS or the court.
Yep. Yeah, the IRS. So, the income tax has to be paid in the amount of 30 to 40% on any settlement. So in that $1 million settlement, typically the IRS is going to get $300,000, right? On any settlement that's awarded, they're going to get 30 to 40%. So here's what happens. Typically, this is not what happens with our clients. Here's what happens typically. The judge uses the charging order and he awards a $1 million settlement. The judge then takes control of the business and pays out that settlement. The IRS gets their $300,000 and everything works out perfectly because of that pro rata distribution language, right? But then comes along our non-pro rata language, and the judge uses the charging order to award that $1 million, but he isn't in charge. He's not in charge. The general partner is, and that's you. And you do not provide the distribution, and the IRS does not get their $300,000. Well, does the IRS ever get cut out of their money? Heck no. So big surprise, they passed a law, which is I'm going the wrong way. IRS ruling 77-137, which states that a plaintiff using the charging order will have to pay income tax on any monetary judgment, even if there's no distribution from the defendant. So let me explain this. They sue, they win. The judge says, hey, pay them $1 million. You say, hey, no thanks. The IRS says that'll be $300,000, pay up. So they owe the IRS $300,000 in taxes on money that they will never receive. And whose problem is that? It's not your problem. So think about that. Guys, with these 4 strategies in place, have we created a nearly impossible situation for a trial attorney? Yes. And we have a 12-year track record with over 12,000 business owners never having a lawsuit continue. And these are the reasons why. If someone even thinks about suing one of our clients, their first call is to us. And as our client, we're going to place a courtesy call to the opposing attorney. We're going to walk them through, our client's asset protection strategy. We take them through strategy 1, safe assets are off the table with the FOP. Then through strategy number 2, all of the other high risk assets are off the table, protected by those individual LLCs. And then we take away the power of their piercing and dissolution with strategy number 3, that Alaskan holding company. And then comes the kicker, strategy number 4. We let them know that all of their entities are written with non-pro rata language. And then for good measure, we let them know that this call has been recorded for quality assurance. And should they continue to sue and win, and their client owes a huge tax bill with no money to pay it, we will happily provide this recording to their client so they can sue their attorney for malpractice. So honestly, guys, put yourself in the shoes of the attorney. You have a suit that comes to you, you look into it, there's nothing to get. And if you try to get around it, you're going to end up getting sued yourself. Do you take the case? No, you drop it. And that's precisely what every attorney has done for 12 years straight. So that's kind of the kind of the summary of the strategies, the 4 strategies I was going to tell you about. But here's where it kind of gets fun. We take it beyond that because there's more to just putting the right structure in place. Obviously, there's some other advantages that come with that. And so for estate planning, we leverage a living trust. And it's not just for the tax benefits, but because it protects your assets after you're gone. I mean, living trusts are not disputable, so they do not go to probate. You don't want them going to probate. If you don't have a will, or even if you do have one, but it's not in a living trust and you die, your entire estate goes to probate and gets chewed up in attorney's fees. So having a living trust is the only way to avoid probate. Living trust cannot be disputed. So what you say is exactly how it ends up. And that's especially important if you have minor children. If you run and own your own business, if you have assets, don't let an attorney have them when you're gone. Make sure that you take care of those you love and those that love you. All right. So all of these strategies are not just preventative measures to save us from ever entering that emotional hell of a lawsuit. They also come with some tax advantages, so it can put a big smile on your face every April when tax season comes around. By putting an extra, $20,000 or so in your pocket, and not in an envelope headed to the IRS. Because is it possible that you're overpaying your taxes? It is. I can tell you that it is. It's very possible, and the IRS knows that better than anyone. So what do they tell you about this overpayment? Do they send you a thank you note, a little gift basket thanking you for your contribution to the American people? I've never gotten one of those. Jasmine, I can see that you've not. I see you shaking your head. Yeah, I've never gotten one of those little baskets. Instead, they issue a statement. You're going to love this. It's very sincere. It says, it's the responsibility of every American citizen to ensure that they do not overpay their taxes. Signed lovingly and sincerely, the IRS. So whose fault is it they're saying that you're overpaying? That's right, it's your fault. And you have not seen anything yet, because if you thought your taxes were bad before, just wait until you pay this year and years into the future. A couple of years ago, they passed one of the biggest tax breaks in over 2 decades. It was a 20% across the board tax break. And as part of this, they eliminated most of the standard deductions. But the problem about this for you, on this call and in passing this tax break, they excluded business owners and people that have their own companies making a certain amount of income. So they excluded you, basically. So I can tell you that the threshold for income is very low if it doesn't affect you. So if you don't change your tax strategy, you're going to be paying more in taxes than you ever have before. That's just the way it is. So how do you do this? How do you pay less? Well, you leverage these asset protection entities and their tax advantages, but you also want to add tax advantage to estate planning. So estate planning has significant, tax savings implications, and it's also just real smart. I mean, if we're going to protect all your assets while you're alive, they're still going to be there when you're gone. So have a plan. Get the tax advantages while you're alive. Your loved ones get the peace of mind. They don't have to deal with probate, and they have the simplicity and security after you're gone. So, between your living trust and your new FLP, your holding company, and your LLCs, each entity comes with several different tax advantages. And we recognize this as a company, but so many of our clients were not taking advantage of these because their CPAs either didn't know how to do it, or didn't have the right documentation to enable them. I mean, I have a great CPA and I love this guy. He deals with the taxes because I don't want to deal with it. But it isn't our CPA's jobs to save us money on our taxes. I'll tell you whose job that is. It's a tax strategist. A tax strategist is basically a CPA on steroids. These guys are complete nerds. And I say that lovingly. They read the 55,000 pages of the tax code to their children at night for bedtime stories. We don't want to be necessarily be those guys, but we really want a person like that on our team. So we went out and hired the best tax strategists around. We put them to work for our clients. Each client is assigned a tax strategist and provided with a detailed tax strategy, fully documented, handed to your CPA, and then our tax attorneys and tax strategists work with your CPA to file your taxes. So we don't want to get rid of our CPAs. We love those guys. We just want to work with them so that they're leveraging all of the various tax advantages that you now qualify for due to your asset protection that you put in place. So, we have clients that are W-2s, we have 1099, we have business owners. I'm a business owner. I've saved over $20,000 a year for the last, 12 years that I've been with Legally Mine. They've handled my taxes. We're going to talk about more of that in just a minute. But, I'm not a tax expert, so don't think that I am at all. I don't like to even think about this stuff, but here's some tax strategies that that we use for our clients. And the most important part about these various strategies is that each one is vetted thoroughly with our tax attorneys and the IRS to make sure that the way we implement this tax benefits is good with them, right? It's got to be good with the IRS, or we're not going to do it. So guys, we don't have time to go into all the details on all these tax strategies, but here's a couple that our clients use every year. Internal Revenue Code 280AG is a very cool one. It allows your business to rent your home for board meetings, trainings, things like corporate events. The money paid to you is tax-free and it's a tax write-off. Another one is income shifting. It can help, pay for college for the kids or even deal with day-to-day expenses of your minor children. A couple of these, you're probably thinking, you've heard about that. You probably have because other people are doing it. So why aren't you? Working with your CPA, we're going to save you a bunch of money. And I'm sure that, you could get excited about the idea that you could have a real, tax strategy that can identify, $10,000 or $20,000 a year in tax savings every year. So we're going to do that for you if possible. So here's another one. It's an R&D tax credit. So let's say that you have a business and you need to go out and, you need to purchase some asset for your business, like, a piece of equipment or something. And you have to do research associated with that. You have to find out the right, equipment to buy or invest in. You have to then train yourself and others to use that equipment as an example. Well, those things, most people don't realize they have a tax credits available to them at the end of the year. They simply have to keep track of the number of hours that they spend in training and in research. And then they assign a dollar value to that, and they get a tax credit at the end of the year. This tax credit was primarily done for big pharma back in 1981. It was modified in 2015, and it made permanent practices and business owners. So that's what it's there for, and it's a benefit that now our clients are able to take advantage of. All right, so we have asset protection. You have your estate planning complete. You've got a full tax strategy complete. This is going to keep you from getting sued. It's going to put an average of $10,000 or $20,000 back in your pocket. So now what do you do? How do you do it? How much time will it take? How do you get it done quickly? Well, let's talk about your options. So one option is working with your regular attorney. You'll probably pay, about $25,000. I can tell you that's low. We're trying to be conservative here. It's probably going to cost you more than that, but let's be conservative. I paid in 1995. I paid more than $25,000 to have my work done. I had invested in a pizza company and wanted to start delivering pizzas. And it's something I hadn't done. I just had a brick and mortar pizza store and was opening up various stores, but I wanted to start delivery. So I went out and hired a bunch of teenagers to drive pizzas to people's homes. And I thought, this is crazy. My liability just went through the roof. I can't, I got to figure out how to protect myself if something happens. So that's kind of why I even started down this path in the first place. So for me, it wasn't just that it was really expensive. The bigger issue is that it takes an enormous amount of time, because you have to track down multiple attorneys that specialize in various things, right? You need an estate planning attorney, then you need an asset protection attorney, then a tax attorney and a tax strategist. But the worst part is that it's so frustrating because none of these guys are working together, and so there's crossover where you don't want it, and they don't do things the way the other group needs it done. So it's so frustrating. So at Legally Mine, we take a different approach. We are a one-stop shop with all these specialties, working together. So, why would we do your estate planning without including your asset protection? Why would we have you spend all that money doing your estate planning when if something happens to you, you could lose everything and you won't have anything left in your estate anyway? And why would we do full asset protection? Take everything off the table, not protect it, and then not do your estate planning. Protect everything from attorneys your entire life and then hand it over to them when you die. And why would we do all of this work for you knowing that there are massive tax advantages and not supply you with the information and knowledge that you need to actually take advantage of those tax breaks? So, we don't do business that way. We do it all. We make it possible to get all of this done for about half the price.